Listen carefully, because this is the part that gets people in Florida in trouble fast. Immigration detention does not cancel your lease. Your housing situation doesn't suddenly switch off just because someone is taken into custody. Florida landlord-tenant law keeps moving on its own timeline, and those timelines are short. So if you're an immigrant in Florida, or you're in a mixed status household, or you're a landlord renting to a tenant who might get detained, this video is about one thing: what actually happens to the apartment, the rent, the eviction clock, and the belongings when someone is suddenly not able to come home. I'm going to explain this calmly, like a real person, not like a robot. But I'm also going to be direct. If you don't understand the deadlines, you can lose the unit and your property even while you're sitting in a detention facility with no clue the clock started. And before we go further, this is general legal information. It's not personal legal advice. Housing and immigration cases can be complicated, and if you're facing this in real life, talk to a licensed Florida attorney. Now let's start with the moment everything changes, the detention. A lot of people hear ICE detainer and assume that means the lease is over. It doesn't. An ICE detainer is basically a request for local law enforcement to hold someone briefly so federal authorities can take custody. Under federal regulation, that hold is limited to 48 hours, excluding weekends and holidays, beyond when the person would otherwise be released. That federal detail matters because it explains something important. Immigration custody is a separate track from your housing contract. The detention system is doing its own thing. Your lease is doing its own thing. Florida landlord-tenant statutes don't include a rule that says tenant detained equals lease paused. There is no automatic pause button. So what does that mean in real life? It means the rent is still due on the same date as always. If your rent is due on the 1st, it's due on the 1st. The lease still exists. The landlord still has the right to demand payment. And if rent isn't paid, the landlord can use Florida's eviction process exactly like they would for anyone else. Here's the part most people don't realize. Florida's eviction process can move faster than families can react, especially if the detained person is the one who pays the rent or holds the bank access. Let's walk through the eviction clock, because this is where things become overnight in the way people actually experience it. When rent is not paid, Florida law allows the landlord to terminate the rental agreement after a very specific notice step. The landlord must serve a written demand, giving 3 days to pay the rent or surrender possession. Those 3 days do not include Saturday, Sunday, or court-observed legal holidays. Now, in a normal situation, a tenant gets the notice directly. But Florida law also allows delivery if the tenant is absent. The landlord can leave a copy at the residence. Think about what that means if someone is detained. The notice can be taped to the door of an apartment while the tenant is in a detention center and never sees it. But legally, the notice can still count. The clock can still start. This is why people feel like things happened overnight. Not because the law literally evicts you in one night, but because the person who would normally respond to that notice is physically unable to see it or act quickly. Now here's a retention moment. Even if you would have paid, Florida law doesn't automatically care why you didn't. The landlord isn't required to investigate detention or wait for you to get access to your money. The system is procedural. So what happens after the 3-day notice? If the rent isn't paid within that time window, the landlord can file an eviction case for possession in county court. Florida gives landlords access to a summary-style procedure in eviction matters, which is designed to move quickly. Now here's the second clock that hurts detained tenants. In an eviction for possession, if the tenant raises defenses other than simply paying, Florida law requires the tenant to deposit rent into the court registry and/or file a motion to determine the amount within 5 days of service of process, excluding Saturdays, Sundays, and legal holidays. If the tenant doesn't do that, Florida law treats it as an absolute waiver of defenses other than payment, and the landlord can get an immediate default judgment for removal with a writ of possession. That's not internet fear. That's how the rule is written. Now imagine being in immigration detention and trying to respond to a county court summons within 5 days, file paperwork, and deposit funds into a court registry. It's not impossible in theory, but in practice it's extremely hard without outside help, legal representation, or a family member who can act immediately. So the system often moves forward without the tenant actively participating, not because the tenant doesn't care, but because they're stuck behind a wall with limited phone access and limited ability to move money around. And then comes the moment that really does feel brutal, the writ of possession. After the landlord wins judgment for possession, Florida law says the clerk issues a writ directing the sheriff to put the landlord back in possession after 24 hours' notice posted conspicuously on the premises. And Florida law also says something that shocks people. The weekend does not freeze that 24 hours. So yes, at that stage it can feel like overnight because the notice is 24 hours. Now the next part is the one that people don't want to believe until it happens. What about the stuff inside the apartment? Florida law allows the landlord, when the sheriff executes the writ or any time after, to remove personal property to or near the property line. And the statute protects the sheriff and landlord from liability for loss, destruction, or damage after removal. So if your documents, your kids' papers, your immigration receipts, your work records, your passport copies, your phone bills, if all of that is inside, this is a real risk. That's why some families say, "We lost everything," not because ICE took the property, but because the housing process hit the finish line while the detained person could not physically pack or coordinate a move. Now here's another twist that many people confuse. Eviction is not the only way a landlord can retake possession. Florida law also recognizes abandonment. Under Florida law, a landlord shall not recover possession except through certain methods, one of which is when the tenant has abandoned the dwelling unit. Florida law says that if the landlord does not have actual knowledge of abandonment, it can be presumed if the tenant is absent for a period equal to 1/2 the time for periodic rental payments. But this presumption does not apply if the rent is current or the tenant has notified the landlord in writing of an intended absence. For a typical monthly rent cycle, half the time becomes about 15 days. That doesn't mean the landlord can always do this automatically. Landlords still have to be careful, but it does show how detention plus non-payment plus no written notice can create a legal argument for abandonment. And here's what makes that scary. Abandonment is often a paperwork and fact question, not something where the tenant automatically gets a hearing first. That's why families get blindsided. Now let's talk about the reality in immigrant households. Most households are not one person living alone. Many leases have multiple adults on them. This is where the next big misunderstanding happens. If there are multiple people on the lease, one person being detained does not erase the lease. The other tenants are still living there. The rent still must be paid. And in many leases, tenants are jointly responsible for the full amount. So if the detained person was the primary earner, the household can suddenly fall behind even if everyone else is still there. Florida eviction filings can name everyone on the lease because the landlord is seeking possession of the unit. That can mean that even family members who are not detained can end up facing the eviction action, and the practical consequences, housing screening problems later, can hit the entire household. Now let's flip the perspective for a moment, because some viewers are landlords or property managers or roommates. If a tenant is detained, a landlord might think, "The tenant is gone. I can change the locks, shut off utilities, and clean out the unit." That is where landlords can get themselves in legal trouble. Florida has a specific prohibited practices statute. A landlord cannot terminate or interrupt utilities, water, heat, electric, gas, etc., to force someone out. A landlord also cannot prevent access by changing the locks or using lock devices. So Florida does not allow the self-help eviction mindset in normal residential tenancies. Even if the tenant is absent, even if you believe they won't return, landlords generally have to follow lawful processes, eviction or a legally supportable abandonment situation. Now let's talk about security deposits, because this is another area where detention creates a real disadvantage. Florida law has strict rules about what happens to the deposit when the tenant vacates. If the landlord doesn't intend to make a claim, the landlord has 15 days to return the deposit. If the landlord intends to make a claim, the landlord has 30 days to send written notice by certified mail to the tenant's last known mailing address, stating intent to impose a claim and the reason. The tenant then has 15 days after receiving that notice to object in writing. Here's where detention causes damage. The last known mailing address is often the rental unit itself, so notices can go to an empty apartment. The tenant may not receive them or respond in time. That can lead to deposit deductions becoming locked in by default. Now, I'm going to connect this to the broader Florida environment, because in 2026, the environment around immigrants in Florida is not just about ICE. It's also about state law and daily life. Florida's SB 1718, signed years earlier, created several ripple effects that matter for housing stability, even if SB 1718 is not a landlord-tenant statute. One major issue is driving. Florida published a list of out-of-state license categories that it treats as invalid if they were issued exclusively to undocumented immigrants, and it did so as part of implementing SB 1718. Why does that matter for eviction and housing? Because people lose jobs when they lose safe mobility. People miss court dates when they avoid driving. People avoid going to the courthouse or the landlord's office because they fear traffic stops. And once a household becomes afraid to move around, small legal deadlines become impossible to meet. SB 1718 also amended Florida's human smuggling statute to create criminal penalties for knowingly transporting into Florida an individual who entered the U.S. unlawfully and has not been inspected since that unlawful entry. I'm not saying everyone is going to be charged. I'm saying the climate creates hesitation. Families get scared to help each other. Friends hesitate to rent a truck. Someone who could have helped remove belongings before a writ gets executed starts thinking, what if I get pulled over? That hesitation can cost people their property. Now, I want to bring this back to the human level, because if you're an immigrant watching this, you don't just care about statutes. You care about what to do. So here are the most practical truths you need to hear, and I'm going to say them plainly. 1. Detention does not erase your rent obligation. The lease continues until it ends lawfully. The 3-day notice can be posted at the unit if you're absent, and the clock can run while you're in custody. 2. Once an eviction case is filed, the response timeline can be extremely short, and Florida has special rules about depositing rent into the court registry within 5 days to preserve defenses other than payment. 3. After judgment, the writ of possession can move with only 24 hours notice posted on the property, and personal property can be moved to the property line. 4. Landlords cannot legally lock you out or shut off utilities as a shortcut. 5. Deposits have strict timelines, and certified mail notices go to the last known mailing address, which can hurt detained tenants who don't receive notices. Now, let's turn those truths into strategy, because this is how you keep your household from collapsing if the worst happens. If you are in a household where one person is at risk, maybe because of an old removal order, maybe because of a past arrest, maybe because your status is unresolved, then you need a plan that does not rely on that one person being free tomorrow. I'm going to describe a plan that is boring, but effective. First, make sure rent payment is not locked inside one person's phone. If only one person has the banking app, only one person knows the login, only one person receives the pay stubs, that's a vulnerability. Fix that. Second, your household needs a simple "if something happens" folder. Physical copies and digital copies, lease agreement, IDs, rent payment history, landlord contact info, utility info, immigration receipt numbers, court dates, copies of everything you would panic to lose. Third, set up a reliable way for someone outside detention to communicate with the landlord quickly. One of the fastest ways households lose everything is silence. Landlords don't like uncertainty. If rent stops and nobody communicates, the machine starts. Fourth, if you're worried about detention specifically, Talk to a licensed attorney about tools like powers of attorney and emergency planning. I'm not going to draft legal instruments here. I'm telling you that families who prepare have dramatically better outcomes than families who only react. Now, I'm going to address something uncomfortable. A lot of content online pretends the solution is, know your rights and you're safe. That's not fully true. Knowing your rights helps, but deadlines and money still matter. If rent is not paid, the law allows termination after the notice period. If the case goes to court and the tenant cannot respond, default becomes likely. If the writ is issued, the sheriff executes it. So the real protective strategy is not only rights, it's also logistics. Who can pay? Who can answer? Who can move property? Who can receive mail? Who can speak to the landlord? Now let me talk to landlords for a moment, because some landlords watching will be thinking, I'm not a bad person, but I need rent paid. Florida law gives landlords procedures, but it also gives tenants protections against shortcuts. Prohibited practices include shutting off utilities or blocking access by changing locks. If you are a landlord and a tenant is detained, the safest approach is still to follow the law precisely. If you're unsure, consult a Florida attorney. Illegal lockouts can create liability. Now back to immigrants and families. The most dangerous moment is not the detention itself. It's the week after, when nobody knows what to do, and the rent deadline hits, and a notice quietly appears on the door, and the person detained has no idea. That is how families lose homes overnight, not because the law literally teleports them onto the street, but because the process continues while they are unable to respond. So when you see viral headlines that say, thousands losing homes overnight, don't just dismiss them, and don't just accept them either. Translate them correctly. The real story is, legal timelines are fast, and detention creates a communication and payment failure that can lead to eviction and property loss quickly. That's the honest, non-dramatic truth. Now I want to give you a final myths versus reality set of clarifications, because this is where misinformation spreads. Myth: if I'm detained, the lease automatically ends. Reality: Florida statutes don't include an automatic pause of the lease due to detention. Rent can still be demanded, and the normal termination notice process can proceed. Myth: the landlord can just throw my stuff away instantly. Reality: Florida's writ process involves the sheriff and 24-hour notice posting, and property can be moved to the property line when the writ is executed. Myth: if my landlord changes the locks because I'm gone, that's normal. Reality: lockouts and utility shutoffs are prohibited practices under Florida landlord-tenant law. Myth: if I don't answer the landlord's deposit claim letter, I lose everything, and that's final forever. Reality: Florida sets notice and objection timelines for deposits. Detention can make those timelines hard to meet. Myth: an ICE detainer means local police can hold me indefinitely. Reality: the detainer request is time-limited and not indefinite. Now, let me end this in a way that actually helps you. If you are watching this and you are scared, don't do the useless thing. Don't just refresh social media for more fear. Do the practical thing. Check your lease. Know the rent due date. Know how notices are delivered. Have a backup person who can pay. Have your documents copied. Know your landlord contact. Make sure your household is not dependent on one person's phone or one person's paycheck access. If you have a heightened risk situation, speak to a licensed attorney about emergency planning. Because in Florida, eviction timelines can be brutally short, and detention can make a normal legal process feel like it happened overnight. That's what's really going on. That's why the fear exists. And that's how you protect yourself, not with panic, but with preparation.